Good day, Crime Talk aficionados. We have a great show for you today. First, new orders from the judge in the Bryan Kohberger matter, and I hate to say who called it. We have a Karen Reed update. A lawyer for Sean Combs gets admonished. This day in legal history and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And you can listen to us anytime on any of your favorite podcasting apps. Now, before we get to today's news, remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do as many background searches on anyone that you desire here in the United States. And when you begin the process, it only takes a few minutes. You are going to get a report literally emailed to you while you wait. And it's going to have all the relevant information that you want. The person's phone number, their email, their social media presence. You're going to find out if they're married. Are they divorced? Do they have liens, judgments against them? Do they have a criminal history? Most importantly, right? And, are they in one of those sex offender registries? Go to crimetalksearch.com. Check out the people that are coming into your life, or maybe you're not sure if you need to get them out of your life. There's something that just doesn't feel right. Go check them out. And the beautiful thing is, whether you want to do one search or 1,000 searches, you can cancel at any time. So go to crimetalksearch.com. You'll be happy that you did. All right, let's go ahead and open the record for Thursday, May 8th, 2025. And first on the docket, the new court orders in the Bryan Kohberger matter. Now, I hate to say that I got it right again. Not trying to say I'm always right, because I make mistakes. But I brought you the show yesterday. The reason why they had this hearing was the order as it relates to the examination of Bryan Kohberger, just like I thought it would. So why would you go? Why would you go to any other source out there for analysis on this stuff? When have we got this wrong? We don't. That's what 30 years and still trying cases brings you. Knowledge, experience, ladies and gentlemen. That's why you're here. All right, let's go ahead and get rolling on it. So in these new court orders, Judge Hippler ruled that Kohberger's immediate family members can support him in the courtroom every day of his high-profile trial, even before they are called to testify against the relatives. Now, the defense had argued that under the Sixth Amendment right to a public trial, Mr. Kohberger has a right to have his family present in the courtroom. But typically, witnesses cannot attend a criminal trial until after they've taken the stand to prevent their testimony being shaped by what they hear in court. It's called a sequestration order, ladies and gentlemen. Anyway, and prosecutors had previously revealed that they plan to call some of Bryan Kohberger's family members, specifically his father, Michael, his mother, Marianne, and the two older sisters, Amanda and Melissa, as witnesses for the state of Idaho. Now, which family members will testify for the prosecution is still a mystery, but those details obviously are closely guarded, but have been apparently submitted to the court for review and have not been made public. So what I intend to do, ladies and gentlemen, is give you a recap of these orders and explain them. And then at basically the end of the show after the dumb criminal, for all the Crime Talk aficionados that just geek out on this stuff, we'll go through the entire order in its entirety. All right. So let's do that. All right. So the judge, probably made the right call in this particular case. I mean, the parents' testimony, interviews, things like that, they're locked into stone. If they deviate from that in any way, they'll be impeached. It's probably not that big a deal. It's a death penalty case. Let his family sit in the courtroom there until they're called. I get that. And frankly, you never know. Sometimes the family hearing it for the first time, sometimes they come around and say, oh my gosh, I didn't realize the facts were so bad. I once had a big drug client who was in federal court, and my client's son showed up and heard the testimony. He kept thinking that she was, my client was, she was innocent. Oh my God, it's terrible. And which is not uncommon. People tell their family different things out of embarrassment or for their own personal reasons. Anyway, and as the trial went on, the kid kind of looked at me and he goes, well, geez, I didn't know all this. I didn't realize my mom was like El Chapa. So sometimes it's good for the family to hear the evidence, because sometimes they tune that out, and it lets them know that the attorneys kind of done everything they can, and this is a bad case. All right. Next, though, let's talk about the next court order. The court also addressed the state's motion to conduct a mental health examination of Mr. Kohberger under the Idaho Code, Section 18207, subparagraph 4, subparagraph C, and to extend the penalty phase rebuttal disclosure deadlines. Now, the defendant's disclosures of the expert opinions on mental conditions relating to the autism spectrum disorder, obsessive compulsive disorder, and attention deficit hyperactivity disorder triggered the state's right to examine Mr. Kohberger. The key dispute were the examination's scope, defense counsel's presence, and the extension of the disclosure deadline. Well, the court ruled on the motion yesterday at this video secret conference, and of the key issues on this particular case. So the extension of the rebuttal disclosure deadlines. First, the issue was the state requested a 21-day extension beyond the examination to disclose its expert's opinion, citing the unexpected withdrawal of their initial expert. The defendant argued there was no good cause and that an extension would prejudice the defense due to the case's timing. Now, the legal standard for an extension requires good cause under Rule 45 there in Idaho, implying unforeseen circumstances beyond the party's control, not lack of diligence. The court considers the potential prejudice to the defendant. The court ultimately ruled. The court granted a limited extension to May 27th, 2025, finding good cause due to the unforeseen withdrawal of the state's expert 2 weeks before the April 28th, 2025 deadline. Now, the shorter extension balances the state's mandatory right to examine Mr. Kohberger with the need to avoid prejudicing the defendants given the trial proximity. So the defendant must be available for examination within 7 to 10 days, giving the state's experts about 2 weeks to complete the report. Court noted the state should have moved for an extension earlier by April 3rd, but found the delay excusable due to the expert's withdrawal. Then the next issue was the scope of the examination, this personality testing. The big issue was the state sought to include personality testing to validate the defendant's self-reported symptoms and rule out other diagnosis. The defendant objected, arguing it exceeded the scope of the rebuttal, limited to just the ASD, OCD, ADHD, eating disorders, and the substance abuse issues, and it violated his Fifth Amendment right against self-incrimination. Well, the legal standard under this Idaho Code Section 18207-4C, the state's examination is limited to rebutting the mental conditions raised by the defendant. The Fifth Amendment waiver applies only to those conditions and not the defendant's entire mental state, the court ruled. Therefore, personality testing was not allowed. The court found personality testing was unnecessary to validate self-reported symptoms, as the defendant's expert, Dr. Orr, relied on extensive external data, interviews, records, rather than self-reports, and the defendant showed minimal self-reporting. Now, testing due to rule out other diagnoses risked generating new evidence beyond the Fifth Amendment waiver, potentially creating aggravating evidence or necessitating further testing, which would delay this case. So the court had to balance what needs to be done. So the defense experts cannot testify about the defendant's lack of personality disorders or reference the state's failure to conduct personality testing. The state's experts may note that personality testing could have aided evaluation, but was not conducted by either side. The defendant cannot imply the state's experts could have conducted such testing, and the defense counsel's presence during examination, which is the other big issue that the court had to address. First, the state sought to exclude defense counsel from the examination room, citing standards of psychological practices and the experts' concern that counsel's presence would affect the validity of the testing and interview. The defendants argued the Sixth Amendment guaranteed counsel's presence, especially in a capital case, as the examination is a critical stage of the proceeding. The court looked at the legal standard and says the Sixth Amendment guarantees counsel assistance at critical stages of the proceedings, but does not necessarily require counsel's presence during mental health examinations. And the court cited to authority on that. Most courts hold that such examinations are not critical stages or that they do not require the right to assistance of counsel and to have the counsel present. Therefore, the court ruled defense counsel's presence in the examination room was not allowed, but counsel for both sides may observe via a one-way video feed or similar method to ensure that there's no interference. Wow. So, but the court did go on and explain that Idaho case law established no Sixth Amendment right to counsel during being present, only basically there to advise before the examination. So the court rejected the defendant's argument that the capital case warrants a different treatment as the case law that the court was relying upon. And just kind of a way of procedural background on this, because it kind of goes to why the state delayed everything. So back in January of 2025, the defendant disclosed their guilt phase expert opinions and their diagnosis of mental conditions. On March 31st of this year, the defendant disclosed the penalty phase expert opinions by 5 professionals. Then on April 2nd of this year, the state and defense counsel discussed the examination with disputes over the personality testing and counsel's presence. And then on April 11th, the state's initial expert withdrew. A replacement was retained by April 18th. And on April 22nd of this year, the state confirmed the new expert's stance and sought a deadline extension which the defendant opposed. Then on April 25th, the state filed the motion. May 5th, the court held a sealed hearing and ruled from the bench. Obviously, what I just discussed. So the order was granted in part with a limited extension of the rebuttal disclosures. The examination is allowed with both sides' counsel observing via the feed, and denied in part in that the state does not get to do the personality testing that they so desire to do for the penalty phase of the hearing. Like I said, I'll go through that further as it relates to all of the full order at the end of the show for those that want to hang out and listen to that. Next on the docket, an update on the Karen Reed case. Well, the Karen Reed trial, day 12, focused on testimony from the Massachusetts State Police Sergeant Yuri Berkenik, a lead investigator in the death of John O'Keefe's, Miss Reed's boyfriend. Now, Reed is accused of striking O'Keefe with her SUV and leaving him to die in the snow outside a house party in Canton, Massachusetts on January 29th of 2022. Now, the defense claims O'Keefe was beaten by another law enforcement officer and Reed was framed. So we talked a lot in this particular testimony by this officer as it relates to the timeline of key events. First, January 28th, 2022, the night before O'Keefe's death, there was the evening at C.F. McCarthy's, which is a bar there in Canton. The officer reviewed surveillance footage from C.F. McCarthy's bar. The footage timestamp was about 12 minutes behind real time. It's always off. It's just always off. Anyway, the observations from the video, which the jury saw, was that Karen Reed has served and consumed multiple drinks. John O'Keefe takes his phone out of his pocket at one point, and then Reed and O'Keefe leave the bar. Reed appears to leave with a drink in hand. Then on January 29th, 2022, the morning of O'Keefe's death, that's when the Canton police get involved. The officer testified. We learned from this officer that he was Michael Proctor's supervisor and was on call and responded to the police department. The Canton police report potential evidence found in the snow as well. There at 34 Fairview Road, there was bottom of a broken cocktail glass, brown paper bag with 6 plastic Solo cups containing possible blood. O'Keefe's phone is provided to the state police. He also testified that the Canton police stepped back from witness interviews due to loose family connections and there was conflicts of interest. We learned that at 5:07 and 58 seconds in the morning, O'Keefe's home, Meadow Avenue, a Ring camera footage from there shows O'Keefe's home shows Reed's Lexus SUV pulling out of the driveway. The officer testifies that the right rear taillight appears to be damaged, consistent with a missing red taillight lens. Now, the morning the investigation begins, the officer and Proctor visit the Good Samaritan Hospital to view O'Keefe's body. The observations were that there was blood pooling under the head, swelling, blood in the eyelids, small cuts near the right eye, the left nostril, bruises and cuts on the right arm, and a bruise on the right hand, an injury to the right knee. They also viewed O'Keefe's clothing, showing it in court. It was soaking wet, and it was bagged and put into evidence. O'Keefe was missing one sneaker, confirmed not the one left in the ambulance. The officer and Proctor visited Reed at her parents' home in Denton, and Reed's black Lexus SUV is parked in the driveway with a large piece of the right rear taillight cover missing. Now, the SUV and Reed's cell phone are seized and taken to the Canton Police Department's Sallyport, a heated storage space, they let everybody know. And then on January 29th, 2022, the evidence collection over several days over there at the property of 34 Fairview Road. The evidence was recovered and photographed by the Canton Police and the Massachusetts State Police in front of 34 Fairview Road. Items collected included various pieces of evidence that we talked about the glass and the taillight lens. February 3rd, they planned the search at 34 Fairview Road, and the officer Proctor, Trooper David DeCoco, and Trooper Evan Brent conducted a search for items, including O'Keefe's missing hat. All recovered items are photographed and placed in collection. Additional testimony highlights the surveillance of the SUV being towed away. And there's video of Reed's SUV being towed. It shows parts of the right rear taillight appearing white, indicating damage to the rear taillight. Obviously, a quick recap of the previous day's testimony focused on the phone data, specifically Jennifer McCabe's How Long to Die in Cold search there on Google. Jessica Hyde testified the search occurred after 6 a.m. Defense claims it was earlier, before O'Keefe's body was found. And the officers, we heard that the officer supervised Mr. Proctor as well, and that this officer that's testifying was disciplined after the first trial for Karen Reed for failing to reprimand Proctor for his inappropriate conduct. Proctor admitted to sending unprofessional, regrettable texts about Ms. Reed to coworkers and family. The officer also recalls seeing some of Proctor's text messages on his Apple Watch, but reviewed them fully only during an internal investigation. They talked about investigation protocols, where the officer explains that Massachusetts State Police procedures. Investigators work in teams for safety and continuity, and the troopers are assigned on-call days to determine who responds to the initial calls. This officer was the supervisor on call, and Proctor was the on-call trooper on January 29th of 2022. Jurors heard a series of of profanity-laced voicemails that Karen Reed left for her boyfriend, Boston police officer John O'Keefe, in the early morning hours on January 29th of 2022. The same day, prosecutors say that she struck and killed him with her SUV. Prosecutors played these messages during the 10th day of Reed's murder, and where she stands accused of murder after backing allegedly her vehicle into O'Keefe outside of that Canton home. She then allegedly left him in the snow to die. The voicemails reads, "You are effing using me right now," Reed said in one message. "You are effing another girl," in another voicemail from Reed, shouting, "John, I'm here. Your kids are effing here. Nobody knows where the F you are. You're an effing pervert." She left several more messages, including one that said, "I effing hate you." There you go, ladies and gentlemen. The defense own words, broken taillight. I just want to know, answer me this, riddle me this. If that taillight is broken and we see it in the Ring video, when did the people at the house at 34 Canton go and break the taillight to plant the evidence? Let me know. Let me know. We had a good discussion with Mama Pink, longtime subscriber on our Patreon show the other night, and just let me know. Just let me know what you think. I personally, I First trial, I would have said not guilty. Prosecution screwed it up. Mr. Brennan, this time, in my humble opinion, is systematically dismantling the defense case this time in his case in chief because, just like I've said before, doesn't go well for the defense second time around. They had their shot. They got that one shot. Didn't quite carry it over the finish line, and the prosecution knows what they're going to do. They're locked into it. It's going to be a much shorter defense case, I do believe. Next, a lawyer for P. Diddy gets admonished by the judge. That's right. A federal judge has warned a lawyer for Sean P. Diddy Do-It Combs to tame his public comments now that the sex trafficking trial is underway, saying that it was, quote, outrageous, end quote, that he referred to the prosecutors during a podcast as a, quote, six-pack of white women, end quote. A transcript of the meeting on Tuesday contained the conversation between the judge and attorney Mark Garagos. Meanwhile, the judge on Wednesday said he will finish seating a jury by Friday. Opening statements are scheduled for next Monday. Mark Garagos, be careful, buddy. Be careful. Next, this day in legal history, on May 8th, 1918, the Sedition Act was passed. That's right, May 18th. 1918, Congress passed the Sedition Act, amending the Espionage Act to criminalize anti-war speech during World War I. It led to over 1,500 prosecutions, shaping First Amendment legal battles, including Shrek versus the United States. In 1929, on this date, the Wickersham Commission formed. President Hoover established the Wickersham Commission to investigate prohibition enforcement and U.S. law enforcement practices. Its 1931 report exposed police corruption and led to reforms in criminal justice. On this day, May 8th, 1933, the Federal Kidnapping Act was strengthened amid the Lindbergh kidnapping case fallout. Congress debated amendments to the 1932 Federal Kidnapping Act. These changes expanded FBI jurisdiction over interstate kidnappings, enhancing federal crime-fighting powers. On this date in 1978, the son of Sam pleads guilty. David Berkowitz, the son of Sam, murderer, pled guilty to 6 murders in New York City. His case prompted the son of Sam's law to prevent criminals from profiting from their crimes through media deals. On this date in 1984, the FBI Cybercrime Unit was formed. That's right, the FBI established a dedicated computer crime task force responding to rising hacking incidents, and it laid the groundwork for the Computer Fraud and Abuse Act of 1986. And then on this date in 1990, the RICO Act applies to anti-abortion protests. That's right. Federal courts were debating the use of Racketeering Influenced and Corrupt Organizations Act, RICO, against anti-abortion protests blockading clinics. The case Now versus Schleider set the precedent for the RICO civil applications. And then finally, our dumb criminal. A mother attacked a cake shop employee in front of her young child and dog after she became infuriated that the size of the cake topper was not what she had ordered. The unnamed employee was working behind the counter at the cake shop when the customer walked in with her child and pet dog. The employee said the woman became visibly upset when she said the animals weren't allowed in the store and immediately confronted the worker about a cake topper she purchased from the store. She wanted it like the picture, the worker said. I was trying to explain to her that we don't know how big anything is from the picture. Well, that's when things got ugly. Well, ladies and gentlemen, to the unidentified cake topper attacker, you are our dumb criminal of the day. All right, ladies and gentlemen, as I said, now we will go through the orders in their entirety on the Kohberger matter if you decide to listen to that. If not, and you're leaving us, remember, have a wonderful day, and the Constitution matters. All right, let's get to the state's motion regarding the examination of Bryan Kohberger. This is huge, ladies and gentlemen. Can you imagine if it took place in every case where the prosecution got to examine the defendant? But when you raise certain defenses, even if it's penalty phase, it's huge. And the fact that the defense attorneys don't get to be there, oh my gosh, they're going to have to watch from a camera. Let's get to it. All right. This is the order on state's motion for 18207 examination and extension of deadline. Before the court is the state's motion to conduct an examination of the defendant pursuant to Idaho Code 18207-4C and to extend the penalty phase rebuttal disclosure deadlines to accommodate opinions arising from the examination. Now, the defendant does not dispute that his penalty phase expert disclosures opining to his medical condition triggers the state's rights under the statute to conduct its own mental health examination. What is in dispute, however, is the scope of the examination, whether the defense counsel may be present, and whether the state has shown good cause to extend the rebuttal disclosure deadline. Now, oral arguments on this motion were held by video conference on May 5th, 2025, at which the court ruled from the bench, and this order memorializes that ruling. Now, here's what I don't get. We get the order, but yet we don't get to see the motions filed. And then on top of that, we don't get to see the proceedings take place. There's nothing in here that warrants such privacy that the public should not have been able to see this. Now, fortunately, this court, unlike others in Idaho, at least it gives us a copy of the order. But it's still frustrating that we didn't get to see everything that takes place. All right, standards. Constitutional questions are questions of law. Whether good cause has been shown for an extension of time is discretion within the court. And on discretionary matters, the trial court must, 1, correctly perceive the issue as one of discretion, 2, act within the boundaries of such discretion, 3, act consistently with any legal standards applicable to the specific choice before it, and 4, reach its decision by the exercise of reason. Court goes into the background. On January 23rd, 2025, defendant timely disclosed guilt phase expert opinions by 2 mental health professionals who examined the defendant and subsequently diagnosed him with various mental and behavioral conditions, including autism spectrum disorder, ASD, obsessive compulsive disorder, OCD, and attention deficit hyperactivity disorder, ADHD. Following those disclosures, the state provisionally retained a psychologist to conduct an examination of the defendant pursuant to 18207-4C and provide a report for rebuttal purposes. The state also moved in limine to exclude the proposed penalty phase testimony by these 2 experts on the grounds that their opinions did constitute a mental element defense and therefore did not fall within the scope of 18207-3. The court ultimately held that testimony by the 2 experts during the penalty phase would not be permitted, with limited exceptions unless defendant testified at trial. On March 31st, 2025, the defendant timely disclosed penalty phase expert opinions by 5 mental health professionals, including the 2 previously disclosed regarding his various mental health behavioral conditions. The deadline for the state's penalty phase expert disclosure was April 28th of 2025. On April 2 of 2025, the state initiated communications with defense counsel about conducting an examination of the defendant pursuant to 18207-4C. Defense counsel responded the same day requesting the name of the experts, the nature of the testing, and whether there was any objection to defense counsel being present for the exam. The following day, the state provided the information requested, including the proposed testing. Among the tests listed was an assessment of personality structure. The state also objected to defense counsel being present. In response, defense counsel did not object to the evaluation, but did object to any testing outside the scope of what defendant's experts had conducted, specifically personality testing. She also asked the state to reconsider its position as to having counsel present during the examination. On April 7th of 2025, the state responded indicating it would not remove personality testing from the proposed examination and would not agree to counsel being present during the examination except through a video feed or otherwise by having counsel shielded from the defendant's view. On April 3rd of 2025, the state's mental health expert informed counsel he was not able to continue on the case. Approximately 1 week later, the state retained a replacement doctor and informed the defendant of such. The state indicated it still needed to discuss the specifics on the examination with their new doctor, including his positions on having counsel present. On April 22nd of 2025, the state alerted defense counsel via email that their new doctor believed personality testing was warranted and objected to counsel's presence. The state also sought a stipulation to extend the rebuttal disclosure deadline for purposes of disclosing the doctor's opinion. Defense counsel responded the same day, objecting to the deadline extension, to personality testing, and to exclusion from the room. On March 25th of 2025, the state filed the current motion. In its motion, the state seeks an order from the court extending the deadline for its penalty phase rebuttal disclosures for 21 days following the completions of the state's expert's examination. 2, allowing the state's expert to administer standardized personality testing on the defendant. And 3, excluding defense counsel's presence at the examination. Defendant responds that 1, there is no good cause for the extension, and it would be highly prejudicial given the posture of the case. 2, personality testing is beyond the scope of rebuttal and would violate his Fifth Amendment rights against self-incrimination. And 3, counsel's presence during the examination is required by the Sixth Amendment. As indicated at the hearing, on the motion, the court finds good cause for a short extension of the deadline. As for the examination, personality testing will not be allowed, nor will counsel's presence in the examination room be allowed. Because the states filed the current motion prior to the expiration of the rebuttal disclosure deadline, the question of whether to extend the deadline is guided by the good cause standard. In the civil context, good cause implies the existence of factors outside the party's control, as opposed to the party's lack of diligence. The reason for the delay must be truly unforeseen and excusable, as opposed to counsel's failure to diligently prosecute this issue before the crisis was upon him. These considerations apply equally in the criminal context. Evaluating these factors, the court finds good cause has been shown for a limited extension of the deadline. While the state should have filed its motion to extend the deadline weeks sooner, the court is sympathetic to the fact that the state's mental health expert, who had been provisionally retained shortly after defendant's guilt phase expert disclosures, decided to withdraw from the case just 2 weeks prior to the rebuttal disclosure deadline, leaving the state to scramble to retain another expert. Based on the state's representations during the hearing, the expert's withdrawal was unforeseen by and beyond the control of the prosecution. Until the doctor was retained, the state did not know his position on the 2 issues holding up the examination, i.e., personality testing and the presence of counsel. Once the state learned of his positions and confirmed defendant's objections, it moved accordingly. Considering these circumstances, the court finds the delay to be more attributable to the prior expert's unexpected withdrawal than lack of diligence by the state. However, the state request to extend the rebuttal disclosure deadline to 21 days after the examination runs the risk of prejudicing the defendant. Given the posture of this case, the volume of discovery, and the upcoming trial date, the court will only allow an extension to May 27th, 2025. Footnote: in its oral ruling, the court indicated the extension would be 21 days from the date of the hearing, which falls on Memorial Day. Due to the holiday, the court will allow the state an extra day. Further, given the deadline following a holiday weekend, the court expects defendant will be flexible if a day or 2 extra is extended. So the court will allow until May 27th, 2025, so the defendant has ample time to consider and potentially respond to the state's disclosure. Defendant shall be made available to the state's expert for examination within the next 7 to 10 days, thus leaving the doctor approximately 2 weeks to complete his report. Personality testing will not be allowed. The state seeks leave to allow its expert to conduct personality testing on the defendants during the examination to confirm, rebut, or otherwise contextualize the neuropsychological conditions diagnosed by defendants' experts, particularly ASD. The state argues there is no basis to limit its doctor's professional judgment as to the appropriate areas of examination, and further, defendant has opened the door by offering testimony about his lack of personality disorder. The state contends it will only seek to utilize the results of the examination as rebuttal evidence in the penalty phase and will disclose all of the results of the examination to the defendant. The defendant objects, arguing personality tests exceed the scope of proper rebuttal. He points out his own expert did not perform personality testing or diagnose him with a personality disorder. Rather, his proffered evidence concerns his diagnosis of ASD, OCD, ADHD, and his history of eating disorders and substance abuse. He also argues the nature of personality testing violates his Fifth Amendment right against self-incrimination. As both parties appear to agree, the scope of the state's examination of the defendant is confined to purposes of rebuttal. This is borne out by the language of Idaho Code 18207-4C, which provides for a limited Fifth Amendment waiver for the mental condition placed at issue, stating as follows. No court shall, over the objection of any party, receive the evidence of any expert witness on any issue of mental condition or permit such evidence to be placed before a jury unless such evidence is fully subject to the adversarial process in at least the following particulars. Raising an issue of mental conditions in a criminal proceeding shall constitute a waiver of any privilege that might otherwise be interposed to bar the production of evidence on the subject. And, upon request, the court shall order that the state's expert shall have access to the defendant in such cases for the purpose of having its own expert conduct an examination in preparation for any legal proceeding at which the defendant's mental condition may be at issue. Idaho Code 18207-4C, the subject to which waiver applies is an issue of mental condition. In other words, the statute does not provide for a waiver of the defendant's entire mental condition. It only waives privileges attached to the mental condition he chose to place before the jury so as to allow the state to controvert his proof on an issue that has been interjected into the case. This is consistent with the well-settled waiver principles under the Fifth Amendment. When a defendant waives his Fifth Amendment right against self-incrimination by voluntarily providing testimony in his own defense, he does so only on the matters raised by his own testimony on direct examination. Indeed, it is recognized among the courts that the waiver under provisions similar to 18207 is limited to the issue raised by the defense. As noted by the Fifth Circuit, by relying on the testimony of a mental health expert who has examined him, the defendant waives his Fifth Amendment privilege. Nonetheless, the scope of the waiver is limited to the issue raised by the defense, and any testimony about the court-ordered psychiatric evaluation cannot go beyond the limited rebuttal purpose. Here, the parties do not dispute that the scope of the state's examination is limited to rebut the mental conditions defendant has placed at issue. They agree that the state cannot explore new diagnoses or mental health conditions other than those placed at issue. What they do dispute is the manner in which the examination may proceed, specifically whether personality testing should be allowed. According to the defendant, the personality testing proposed should not be allowed because it is not aimed at revealing proper rebuttal evidence. He points out that the rebuttal evidence explains, repels, counteracts, or disproves evidence which has been introduced by or on behalf of the adverse party. There must be a nexus between the purported rebuttal evidence and the evidence that the purported rebuttal evidence seeks to rebut. Defendant notes that his proffered evidence is limited to his diagnosis of ASD, OCD, ADHD, and history of eating disorders and substance abuse. Because he has not been diagnosed or even tested for personality disorder, he argues testing for such is beyond the scope of rebuttal. In support, the defendant cites to several cases where courts have limited the types of testing conducted in rebuttal examinations based upon the scope of the mental health evidence proffered by the defendant. For example, in United States v. Taylor, the defendant sought to introduce expert evidence regarding his developmental history and mental conditions related to substance abuse during the sentencing phase and was ordered to submit rebuttal examination. The defendant subsequently objected to 4 tests the government intended to use, including personality testing on the grounds that those tests were designed to indicate personality disorders and mental conditions, not mental conditions related to substance abuse, and therefore exceeded the scope of the Fifth Amendment waiver. The court agreed, concluding that the government could use such tests only to the extent that the test contained testing scales for substance abuse and that the prosecution should be barred from introducing any material that are outside the scope of the mental health testing for substance abuse. The state responds that it is not proposing the personality test simply as a fishing expedition. Rather, he believes the test will aid in rebuttal for several reasons, as he explains. In my professional opinion, including broader testing of personality and psychology is important for several reasons. First, These tests contains the most sensitive symptom validity measures that help determine if the examinee is reporting information in a consistent and reliable manner without significant over-reporting, exaggeration, or under-reporting, defensiveness. In her evaluation of the defendant, it does not appear that Dr. Retrial Orr administered any tests that formally evaluate symptoms validity to this level. These validity measures help ensure that the results of other self-reporting measures that do not contain validity scales are valid. Second, not only is it important to rule in diagnosis such as those that have already been diagnosed, but also to rule out a diagnosis that could account for the same symptom presentation. The diagnostic criterion for many disorders includes these symptoms and are not attributable to or are not better accounted for by another condition. Therefore, ruling out those conditions is important. Third, with autism specifically, there are certain personality characteristics that are common and supportive of that diagnosis. Obtaining information about those characteristics helps ensure a proper diagnosis. The battery of testing that I propose would be significantly less than the testing battery already completed by Dr. Orr. The battery would serve to supplement the battery that Dr. Orr completed and provide additional valuable information. In my professional judgment, I would not administer the hair PCL-R that is discussed in the defense report by John F. Edens, PhD. The state also notes that to the extent the testing strays from its rebuttal purpose in any respect, there is no prejudice to the defendant because he will have a chance to object prior to the admission of evidence at trial. To this end, the state cites to various cases where courts have declined to impose strict limits on the scope of court-ordered psychological exams, observing that even if the examination exceeds the scope of reasonable rebuttal, it will not be admitted at trial. The court's concern with allowing the state's expert to conduct personality testing is twofold. First, the court is not convinced from the expert's explanation that the testing is within the scope of rebuttal. The first purpose identified, i.e. to ensure defendant's self-reported symptoms, particularly to Dr. Orr, are valid and might carry great importance if Dr. Orr's diagnosis were made largely based on defendant's self-reporting, but they were not. Dr. Orr's neuropsychological examination included extensive interviews with the defendant's family members, co-workers, former teachers, and psychologists, and an evaluation of defendant's health and educational records. Moreover, Dr. Orr specifically observed that on symptom inventories, defendant chose not to comment on any concerns about himself, and he showed very little insight into his behavior and emotions. In other words, there was very little by way of self-reporting symptoms. Consequently, the court struggles to understand why it is necessary to test the validity of self-reported symptoms through personality testing. The court's second and more significant concern is with the use of personality testing to rule out other diagnoses of or personality characteristics that may account for the same symptoms. This has the potential of generating new mental health diagnosis or other evidence outside the scope of the defendant's Fifth Amendment waiver. While the state asserts that its experts does not intend to explore new diagnosis or mental health conditions, there is a fine line between ruling out other health conditions and exploring them. The danger of that line being crossed is too great and could lead to evidence that could be viewed as aggravating in nature, or at least make it difficult to parse the aggravating evidence from the mitigating. Moreover, considering that the court is allowing the state an extension of time to examine the defendant and disclose its expert opinion, time is of the essence. Any new potential diagnosis or evidence uncovered through personality testing may elicit the need for further testing and surrebuttal by the defendant, as well as significant post-examination motions practice. Weighing the marginal utility of personality testing in this case against the existing time constraints and the timing of the state's motion, considering its knowledge of the scope of the defense agreement, the court will not allow it. However, to equalize the playing field, the court will not allow defense experts to testify about whether a defendant meets or historically met the criteria for personality disorder, or reference the state's failure to conduct personality testing on the defendant. In other words, defendant cannot use personality disorder or the asserted non-existence thereof and the lack of testing for it as a shield and a sword. Moreover, the court will not prohibit its expert from commenting on the fact that personality testing may have aided in his evaluation, but that testing would not be performed by the defense expert, nor available to him. In turn, the defendant may not assert or imply that the doctor could have conducted personality testing. This approach strikes a balance between ensuring defendants' rights are preserved while at the same time allowing the state a means of effective rebuttal within the time constraints posed by the extension. The Sixth Amendment does not require counsel's presence at the exam. Finally, the state seeks to exclude defense counsel from its examination, asserting defendant has no Sixth Amendment right to the presence of counsel at the examination. It further argues exclusion of counsel is consistent with standard psychology practices and the American Bar Association standards on mental health, which advise that defense counsel should only be present if requested by the evaluator. According to the doctor, defense counsel's presence would interfere with the validity of the examination. He also points out the defendant was examined by his own experts. Defendant responds that he has a Sixth Amendment right to presence of counsel during the examination because it is a critical stage in the proceedings, particularly given that this is a capital case and death is different for Sixth Amendment purposes. He further notes that having counsel present is consistent with the American Bar Association guidelines for the appointment and performance of defense counsel in death penalty cases. The Sixth Amendment to the United States Constitution provides in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. It guarantees a criminal defendant the right to counsel during all critical stages of the adversarial proceeding against him. The test for whether the stage is critical is whether the accused finds himself confronted, just as at trial, by the procedural system or by his expert adversary or by both. With regard to court-ordered psychiatric examinations under 18.2.207, no Idaho appellate court has expressly held that the examination itself is a critical stage of the proceeding, thus triggering the Sixth Amendment. However, in State v. Payne, a capital case, the court held a defendant has the right to assistance of counsel as opposed to the presence of counsel during a compelled mental examination. By the holding, the court implied that 18.207 examination was a critical stage, but did not pass on the question. In Estrada, the case Payne cited for his holding, the court held that the decision of whether to participate in a psychosexual exam was a critical stage, triggering the defendant's Sixth Amendment right to counsel. Although the defendant did not assert he was entitled to counsel's presence during the examination, the court added that the Sixth Amendment right to assistance of counsel in the critical stage of a psychosexual examination, inquiring to a defendant's further dangerousness, does not necessarily require the presence of counsel during the exam. Read together, Payne and Estrada suggest that regardless of whether an examination under 18.207(4)(c is critical stage or not, the Sixth Amendment does not provide a right to the presence of defense counsel during the examination. In fact, subsequent case law from the Idaho Court of Appeals supports this conclusion. In Hughes v. State, the Court of Appeals squarely held the Sixth Amendment did not require the presence of counsel at compelled psychosexual examinations, even if they were a critical stage. In doing so, the Court of Appeals examined Estrada's length, particularly the efforts made by the Idaho Supreme Court to distinguish between the right to assistance of counsel under the Sixth Amendment and the limited right to appointment or the presence of counsel recognized as the Fifth Amendment safeguarded in Miranda. In making this distinction, Estrada drew from Estrella v. Smith, also relied upon by Payne, where the United States Supreme Court held that capital defendants' pretrial psychiatric evaluations was a critical stage of the proceeding, but his Sixth Amendment right only encompassed the right to assistance of counsel before submitting to the examination. In its opinion, the Estelle Court observed that the defendant was not seeking the right to have counsel actually present during the exam, and noted that because the psychiatric evaluation at issue was conducted after adversary proceedings were instituted, and the court was not concerned with the limited right to the presence of counsel recognized as the Fifth Amendment safeguarded in Miranda. Based on these distinctions drawn in Estrada and Estelle between the Sixth Amendment right to assistance versus the limited right to the presence of counsel under the Fifth Amendment, the Court of Appeals in Hughes rejected the notion that the Sixth Amendment provides an absolute right to the presence of counsel during a psychological examination, even if it were determined to be the critical stage. Rather, the Sixth Amendment simply guarantees the defendant the advice of counsel prior to submitting to the examination. The Hughes opinion and its examination of Estrada and Estelle shed light on what the Idaho Supreme Court intended in Payne when it held that the defendant undergoing a compelled mental examination under Idaho Code 18207 has a Sixth Amendment right to the assistance of counsel as opposed to the presence of counsel. Whether or not the examination itself is a critical stage, the Sixth Amendment right is only one of assistance, not presence of counsel. Indeed, most courts have concluded that a defendant has no constitutional right to be represented by counsel during the examination, either because the examination is not considered a critical stage or because the Sixth Amendment carries a right to the assistance rather than the presence. Defendant, however, contends that Payne is not controlling and relied upon dicta from Estrada. Dicta is basically like a footnote. It's non-binding authority, but it can be persuasive sometimes. He noted that Estrada declined to rule on whether the Sixth Amendment mandated the presence of counsel during the compelled mental examination. Regardless of whether the statement was dicta in Estrada, Hughes squarely held the presence of counsel was not required at compelled mental examinations. Further, although Payne may have cited a dicta, its holding was not. At issue in Payne was whether counsel rendered ineffective assistance, a Sixth Amendment claim by, inter alia, among other things, failing to be present during the examination. The court held the Sixth Amendment did not carry a right to the presence of counsel at the examination, thus Payne is controlling. The defendant also contends that the plain language of 18207-4, referring to the adversarial process triggered by a defendant placing a mental health condition at issue, indicates that the examination is adversarial proceedings, unlike psychosexual examinations where the expert is court appointed. However, even assuming the examination itself is an adversarial process and therefore a critical stage, Payne instructs that there is no right under the Sixth Amendment to the presence of counsel at the examination conducted by the state's expert. Defendant further cites to a handful of cases where courts have found a right to presence of counsel during the psychiatric examination. In two of those cases, the right was not derived from the Sixth Amendment and therefore not instructive here. In Houston v. State, in which the Alaska Supreme Court held the guarantee of effective assistance to counsel provided in Alaska's Constitution required the presence of defense counsel during a mid-trial psychiatric interview, which was conducted by the prosecution pursuant to court order. However, the Alaska Supreme Court is not limited by decisions of the United States Supreme Court or the United States Constitution when it expounds its state constitution. The Alaska Constitution may have broader safeguards than the minimum federal standards. Thus, how the Alaska Supreme Court chose to interpret the counsel guarantee provided in Alaska Constitution is not particularly useful. Similarly, in State v. Maine's, defense counsel was present at a psychiatric examination, not due to a Sixth Amendment right, but because the district court ordered his presence when the court ordered the examination. In the two other cases cited by the defendant, the right to counsel's presence was limited. In People v. Guevara, the court held defense counsel's exclusion from the defendant's pretrial psychiatric examination was reversible error based upon Lee v. County Court of Erie County. However, Lee limited the right to observations only to make more effective the basic right of cross-examination should the examining psychiatrist be called at trial. Lee also permitted the prosecutor to be present. Similarly, in State v. Hutchinson, the Supreme Court of Washington found the defendants do have a right to the presence of counsel at court-ordered examinations, but only as observers. However, these two cases fall into the minority of courts which have determined the issue. Further, courts in the majority have cited a grave concern with this approach because the potential for defense counsel's mere presence to disrupt the dynamics and therefore the effectiveness of the court-ordered examination, as noted by the D.C. Circuit in U.S. v. Byers. Even if counsel were uncharacteristically to sit silent and interpose no procedural objections or suggestions, one can scarcely imagine a successful psychiatric examination in which the subject's eyes move back and forth between the doctor and his attorney. Nor would it help if the attorney were listening from outside the room, for the subject's attention would still wander where his eyes could not. In addition, the majority of courts recognize that the need for counsel's presence is obviated since the accused's privilege against self-incrimination will be given full effect in regards to his inculpatory statements to the examining expert on the issue of guilt and punishment. Indeed, where counsel is relegated to a purely observational role during the examination, it is difficult to see how assistance is provided as contemplated by the Sixth Amendment. As to the defendant's argument that death is different, implying that the more robust Sixth Amendment rights should apply, Payne, also a capital case, declined to find rights under the Sixth Amendment to the presence of counsel in an 18207 examination. As mentioned, Payne is controlling. That said, the court will allow counsel for both sides to watch the examination through a one-way video feed or some similar method that prohibits them from being seen or heard during the examination. Under no circumstances will counsel be able to interrupt the examination. Boom. Order. Based on the foregoing, state's motion for examination of defendants pursuant to Idaho Code 18207 and for an extension of time to compel rebuttal penalty phase expert disclosures is granted in part and denied in part. The other motion of relevance as it relates to the defendant's family says in its order on motion in limine regarding the family members in the courtroom, April 16th of 2025, the court ordered the state to submit for an ex parte in-camera review a list of the defendant's immediate family members it intends to call at trial. The purpose for calling each of them, whether they can be called early in the case, and why exclusion from the courtroom prior to providing testimony is necessary. The state timely complied with this directive. Having considered the state's response, the court, exercising its discretion, finds good cause to excuse defendant's immediate family, i.e. parents and sibling, from the anticipated exclusionary order, which would be entered pursuant to Idaho Rules of Evidence 615 prior to trial, aka a exclusionary rule. The United States Supreme Court has recognized the right to a public trial afforded by the Sixth Amendment entitles a criminal defendant, at the very least, to have his friends, relatives, and counsel present, no matter with what offense they may be charged. Courts recognize that having a defendant's family members present at trial advances the value served by the right to a public trial, ensuring fair proceedings, reminding the prosecutor and judge of the grave responsibilities, discouraging perjury, and encouraging witnesses to come forward. Like other constitutional rights, the defendant's rights to a public trial is not absolute. The right to an open trial may give way in certain cases to other rights or interests. Here, the court must balance defendant's rights to have his family members present at trial against the state's interest in excluding testifying witnesses from trial under Rule 615. The purpose of exclusion of witnesses under 615 is to reduce the possibility of a witness's shaping his testimony to conform with or to rebut prior testimony of others. Under the circumstances here, the court does not find that excluding the testifying members of the Kohberger family will serve this purpose. Namely, the scope of the family's members' proposed testimony is very narrow and is not necessarily tied to the testimony of other witnesses. Further, the family members were previously interviewed regarding the matters in which they will be questioned at trial. These prior recordings serve to protect against any attempt by the family members to mold their testimony based on how others testified before them. In addition, the trial publicity is such that the defendant's family members are likely aware of what the testimony and evidence will be in the state's case in chief. Thus, exclusion pending their testimony will not necessarily prevent them from conforming their testimony. Finally, the state has indicated it would prefer that the family members remain in the courtroom and be called when the state sees fit, rather than calling them out of order as witnesses. In sum, given the defendant's right to a public trial in general, the importance of the presence of his family members to both the defendant and the family members, the exclusion of his testifying family members under 615 will not advance the purpose of the rule. The court will allow them to remain in the courtroom throughout the trial. All right. And there was one other order where somebody filed a motion for access to non-disclosed records, and the court said, you have no standing, put in a request for the information through the appropriate procedures. All right, that's all we have for you today, ladies and gentlemen. Hope you enjoyed it. Once again, thanks for watching, and remember, the Constitution matters.